when we're thinking about condominiums, most people are thinking high rise. The late night party in that setting may rise to a nuisance much faster than it would in a single family home where people have detached homes. They're not living right next door to each other, right? That intolerable circumstance that night, not only could it be a nuisance, but more likely too, it's also probably a law enforcement issue.
Welcome to the Uncommon Area, where we're dedicated to reimagining HOAs. We provide board members and managers with the resources to create uncommon communities where residents love their HOA and truly love where they live. Welcome to the Uncommon Area. I am Matthew Holbrook, and in this episode, I am joined by attorney Darren Bevan of the law firm of Bydullen and Jacobson, and we talk about the role of an HOA in addressing conflict with your neighbor. Oftentimes issues arise where neighbors are going at it over whatever the issue might be, and sometimes the HOA needs to be involved and sometimes the HOA should not be involved. And so Darren and I talk about those types of issues in this very engaging episode. Well, Darren, thank you so much for joining us in the Uncommon Area. We are going to talk today about neighbor-to-neighbor disputes and issues between neighbors in homeowners associations. So that never comes up, right?
Only every day.
Yeah, so that's all.
The problem you always have is when you have a bunch of folks living together, especially in a closer knit community where homes are closer together, you often have times, if not frequently, have problems between neighbors, just general disputes.
Yeah. So the question comes up, what is a homeowners association's obligations to do when neighbors have disputes with each other? So I thought we could start with, is there any kind of case law or cases that might inform a board as to how they should think about neighbor-to-neighbor disputes?
Yeah, and there's actually quite a few, but most importantly, we have a recent one that came out in December of 2024. And this is a case that involved an association where not only was the association in trouble according to the owners, and the tenants were in trouble, but also the management company in this case. And so it's a very helpful case in explaining this situation where not only could the association be held responsible, but these tenants tried to hold the management company also responsible. And in essence, what was going on is you have these fights between two neighbors. And the association was receiving repeated reports from the tenants that were living there and also from other neighbors saying, there's something wrong here. They're fighting constantly. There are all these disruptions, all these disputes between the folks. And the board and the management company both smartly said, before we do anything, we need to find out what's going on. Right? We need to investigate. And that's a key element that sometimes boards, sometimes even managers might forget. Right? The report of a violation of our governing documents comes to the association. And the very first thing that we should always be thinking about is this truly a violation of something that we as an association are responsible for? And the nice thing about this case that came out in December is the court ultimately said that is the limits of both the board and the management company. Unless there is a finding by the board that the association's governing documents have been violated, whether that's the rules or restrictions in the CC&Rs, the court said the board does not have to step into every single dispute. And this has come up in the past, right? There's been a number of cases that have spoke about this issue tangentially, meaning there's a case called Behan versus Lido Isle from 1977 that spoke sort of to this issue, but not directly.
So what you're saying is the first and primary measurement about whether the association should get involved is a tie back to, is there a specific portion of the governing documents where there's a violation?
Correct. And that's the fundamental question that the board and management should be asking.
So it's not just, is there a dispute, but is there a dispute that is based on something in the governing documents that's been violated? You have to ask that question and have a specific answer to it if the association gets involved.
Correct. And the worry that you always have is that sometimes even I will get a communication from a client saying, this owner, we'd like you to send a letter to. And the reason why is because they're doing this activity, which that conduct, in our opinion, is a violation. And fundamentally, sometimes you do run into situations where, in fact, there is no violation, right? If it's an owner, say they're walking down the street holding a beer or an alcoholic beverage, is that clearly a violation of our governing documents? That's what needs to be investigated and determined by the board. Or two owners yelling at each other, right? They're in the hallway yelling at each other, or some sort of threatening behavior, which is really more of a law enforcement issue, right? A lot of folks think, the association should be the one stepping in here.
Yeah.
And, we see that many times in communities where an owner might, before they even call law enforcement, call the management company. And that is oftentimes, one, it's a bad decision, right? We're not law enforcement. As the court said in the Woolard case, we don't have police powers. We don't have subpoena powers. We are not law enforcement. We don't have the power to arrest. And so when you're thinking about what is our authority, what can the association do, that is really the big first question is what's going on, investigating to determine what those facts are, and then a determination as a very first step, is this in fact a violation of any restriction or rule contained within the governing documents?
So there's a couple of principles that you've laid out here. Again, we are saying there needs to be a violation of the governing documents. Secondly, and related to that, there are a lot of things that people do that might be, we'll say, inappropriate or even illegal. And maybe we'll come back and unpack some
Yes,
examples there. But inappropriate or illegal does not necessarily mean violation of the governing documents.
correct.
So inappropriate behavior, illegal behavior very well may not fall under the jurisdiction of the association. And then the other point I wanted to raise that you were bringing up is one of the examples was two neighbors yelling at each other. Now, just as I'm processing this from a
Mhm.
manager's standpoint, um, that might not necessarily be a violation, but of the governing documents, but it could be.
It could.
It might you might be able to argue that it falls under a nuisance clause. And so I wanted to unpack that a little bit because that nuisance factor in governing documents seems to be potentially a catch-all. And so would imagine managers, board members listening to this, that's where their head might go, that if something is happening that's inappropriate or illegal, maybe we could capture that under the
Under the
nuisance angle.
nuisance.
How do you see that?
Well, and that's the nuisance, as I always say, well, it's not hard. It's pretty hard to say, but it's pretty hard to prove too. So when you think about a nuisance, generally has to be something ongoing, substantial that is impacting the ability of someone to live in their home or affecting their home in such a way that it has any reasonable person looking at it would say, clearly no one should be expected to live like that. And so that's where you run into the issue. For example, the owners yelling at each other in the hallway. They're in the building, they're yelling at each other. It's quite noisy for a few minutes, but then it subsides and it disappears. Is it still a nuisance despite only happening in this short window of time? That's a very fact specific argument to make. It just fundamentally is not rising to the level that a court would say, no one could tolerate this, no one could live like this. And so while nuisance feels like a catch all, it is actually more precise than that, in that it does have to be some sort of ongoing, substantial, and unreasonable conduct that is impacting another property.
So the key words on what you were just saying is ongoing. So it's not just a brief moment in time. Substantial in that it's not just a minor thing. It has to have some significant impact on quality of life. And that's measured by a reasonable person.
Correct. And it's that reasonable person standard. It's not, because sometimes you do become what I would call like the eggshell neighbor,
Yeah.
right? Somebody has their music up loud all the time. Clearly that can be a nuisance. But over time, people do become more sensitive to those types of issues. And the big thing about the association's role is that the hope is we can look at as an independent third party and say, yes, no reasonable person could live like that. Whereas the owner might be saying any noise that neighbor makes is intolerable.
So let's unpack that just a little bit further. Um, a common issue in a homeowners association is late night parties.
Correct.
Um, so address that, and I would separate it between, let's say, high rise community where there is very close confines where people are living together versus a single family home community where some
Where
and
there's more space.
where there is a little bit more space, and talk about both of those where it's a single incident. So it's not, I'm picking at the definition of ongoing. It's a
Yes.
single incident, but it is a lengthy single incident where it goes on till late hours of the night. Is there a difference between the high rise community and the single family home community? And could one instance of that constitute a noncompliance?
And I think the key to remember is remembering your community, right? Every community is different. Every community has its own character, its own nature. Condominiums, the density generally, right? There are many different types of condominiums too. Always remember that. I have condominium clients that are in essence single family homes.
Yeah.
When we're thinking about condominiums, most people are thinking high rises. They're thinking larger buildings, more density, more folks living closer together. The late night party in that setting may rise to a nuisance much faster than it would in a single family home where people have detached homes. They're not living right next door to each other, right? That intolerable circumstance that night, not only could it be a nuisance, but more likely too, it's also probably a law enforcement issue.
An association could set quiet hours in a community.
Correct.
So that there could be a violation of their documents in that case if they have a rule that specifies quiet hours start at 10 p.m. and somebody's having a raging party that goes, well past 10 that's very loud.
That's actually the easy violation, right? Because you're looking at it saying, listen, the noise level at this time is supposed to be X. Now, one of the big things you always have to think about too is this third party investigation. I have some clients, we have decibel meters.
Yeah.
That the association is using to determine how loud is the music, because the concern is, the neighbor who is constantly reporting, the neighbor that has the loud music or the loud sounds coming from their home may be overly sensitive or may just be sensitive to that noise. And so having a third party, the association, investigating to determine whether in fact is a violation as we define it in our governing documents is an important step. And using tools like decibel meters, using tools like using guard services or the patrol services to investigate whether or not something to this nature is happening is key to the association's work, because what we're doing is we're independently verifying whether or not there is in fact a violation. And part of that is that we don't have to rely necessarily on the neighbor that's making the report that way. And it makes their life a little better, right? They perhaps could step away and we can clearly identify there was a party, the decibel levels were at X level. These are the rules that it violated. And because of that, we don't have a choice but to enforce our governing documents.
Yeah. So I want to push a little bit back on the idea of a homeowner whose behavior is inappropriate or even illegal, and maybe talk through some examples of that. You brought up the idea of somebody walking down the street carrying a can of beer. Different people might measure the appropriateness of that or not. Some people might say no big deal, and others might
Might be
bothered.
offended. Yeah.
But chances are there's nothing in the documents that is going to speak to that particular issue. I was telling you one of the instances I had very early in my career when I was managing associations was a situation in a community where there was a man who regularly walked through the community in the common area with no clothes on.
Yes.
And there was a desire on the homeowner's part and the surrounding homeowners and from the board that we would send a non-compliance notice
Correct.
to this owner. And your response in light of the things we've been talking about is what?
It's typically one, is it a violation? It may be illegal, right? It may be a crime even in some jurisdictions. But is it in fact a violation of our governing documents? And oftentimes amongst many communities, no, it's not. Because we're not contemplating that sort of behavior when those documents are being written. The board may later address it. So for example, you have a swimming pool. I've had that before, where someone is nude sunbathing in the swimming pool at the common area. That is something we could adopt a restriction on. But typically, that's not something that's just going to come out of the blue and the board's going to say, gosh, we really need to make sure that this is occurring or not occurring within our community. But generally speaking, somebody can be committing a crime and yet it's not a violation of our governing documents. And in those settings, it's typically a matter of informing the owner who's making the report or the resident who's making the report. This is really a call to law enforcement.
Yeah.
It's something beyond our control and beyond our power. And fundamentally, we don't enforce state, county, or local laws. Those are left to the governmental entities to enforce those requirements, just like the state leaves it to us to enforce our requirements.
Yeah.
And so you kind of think of that overlay. There are times when something may be offensive, maybe immoral, maybe improper, but it's not always a violation of the governing documents. And that's where the investigation by both the board and management becomes critical to these sorts of situations, because it's really, one, bringing the board up to speed so they're aware of what's going on in the community, so that maybe we do need a rule, right? If that was occurring at the common pool, we may want to adopt a rule saying some level of swimwear must be worn at all times. That might be beneficial for that particular community. And so that's where that investigation is helpful, because it can come before the board and say, hey, we received this report. We determined that we couldn't identify any restriction in our governing documents that this offended. And as a consequence, we took no action, but we just want to make sure the board was up to speed as to what we had found in our work.
Yeah. So one other example, activity that is going on in someone's rear yard that would not be drawing attention unless you looked into their rear yard. So I'm excluding, noise issues still could go into that previous conversation we were having.
Right.
But if you looked into somebody's backyard and they were doing something that was inappropriate or even illegal, again, if it's not a violation of something specific in the association's governing documents, there's not much that the association should do there.
They should not. I
They
mean,
shouldn't
that's
do
real.
anything.
They should not. I mean, really, when you think about it, it's kind of it may be improper, it may be illegal, but fundamentally, the association's role is generally not in that category, right? We are not law enforcement, as the court in that appellate case very clearly stated. We don't have their powers, right? A law enforcement entity, whether it's a district attorney or police officers or sheriffs, they have subpoena powers. They have investigative rights that associations just do not have.
No.
And so when it comes to backyards, generally speaking, unless your governing documents specifically address it, or that the backyard is visible from the common area, I generally would recommend that most of the time we're going to be staying away from that category of potential violation or violation of the law.
Great. The case that you referred to from December of 2024, what's the name of that case?
It's Woolard, a few other names, but it's Woolard v. Regent Real Estate Services.
Okay.
And this is a very recent case that, like I said, the board did everything right in that case. They received reports from our neighbors, from their members, explaining what was going on. They then took the right step, and investigated what was going on. And then at the conclusion of the investigation, they reported out to those folks that were making these claims, explaining why the association chose to take no action. And the court said, that's exactly what we expect. This is the expectation of a reasonable investigation. We always call this thing called business judgment rule, right? That the board must act reasonably. They must act in good faith in the best interest of the association. In essence, what the court said, without necessarily saying that, they said they met the requirements of the business judgment rule. They did what they were supposed to do. Just because you investigate something doesn't mean you have to find a violation. There's even going to be times when a board may say, that violation does not generally affect the association. And it might be another time that the board says, this is an area we're not going to step into because it doesn't affect the community as a whole. We do have some discretion under California case law that speaks to the board as the governing body of that association has the ultimate decision-making authority how and when to enforce its governing documents, which is fair and reasonable, right? It's just like law enforcement.
Yeah.
They don't have to pull over everybody on the freeway to give everyone a ticket, but they have some discretion, and boards have some discretion as well. While they cannot ignore a blatant, obvious, impactful violation, there may be times that they find either it's an illegal act, or it's an act that's not a violation of our governing documents, or it's something that our documents may even restrict us from addressing.
Yeah. I would imagine that a board looking into and doing an investigation into any of these issues, even if they choose to do nothing about it, it would be helpful for them to document that
Yes.
and maybe even record that in executive session minutes.
Yeah, and
to
what
address
we
that.
typically recommend is kind of a multi approach when it comes to documenting it, right? Because what happens to memories? They fade. We could joke about, what did you have for lunch last week on Wednesday? And you may not remember. And so documenting the decision of the board in both executive session resolutions and also communications to those making the reports are critical to success, right? Governance is successful when we have trust, faith, and confidence in those who are governed. And the board taking that extra step to adopt a written resolution explaining what they did, how did we investigate, who did we talk to, going to some level of detail so that way we have a record of what we did at that time and why we did it. And that's an important role the resolution plays, is it's an internal document where the association's board is speaking to itself in essence, but also speaking to future boards as to why it made this decision and why it did what it did at that time. That is, I think, a critical step because it helps to, one, remind the directors what they did, right? I may not remember what I did at last month's board meeting, but if I look at that resolution, I will.
Yeah.
And so that's helpful. But then also the communication back to the persons making the report is helpful and beneficial to the association because it in essence closes the loop. It says, yes, we received your report. We took it seriously. We were concerned by the issues you raised. We investigated it. We made these findings, and we're now reporting to you either we're going to be taking action or we're not going to be taking action. And I think that's beneficial to everybody in building that good governance model where the members say, I may not like the decision, but at least I could understand it.
Yeah. Well, that's really helpful, Darren. All of this is very practical and things that come up for managers and board members every day. So really appreciate your input.
Yeah, no, it's a pleasure to meet with you. And it's a pleasure speaking with everyone.
Great. Thank you.
Well, I appreciate Darren and his insight and perspective on these kinds of issues in homeowners associations. And if you found this episode to be particularly helpful, I would really appreciate it if you would like and subscribe to the Uncommon Area and tell somebody else in the HOA world about this podcast.